Sorry I'm late. How are you a minute? Apologize. Senator Harris, is she available? Senator Harris, if you could, there you are. We see you. Can you say something? Can you hear me, Senator?
Yes, I can.
Okay, great. Okay, the floor is yours. Senator Harris.
Thank you, Mr. Chairman. First, I want to extend greetings to Judge Barrett, and I look forward to our conversation this evening.
Thank you, Senator.
Thank you. Before I begin, I wanted to take a moment to talk directly with the American people about where we are and how we got here. So we are in the middle of a deadly pandemic that has hit our country harder than any other country in the world. More than 215,000 of our fellow Americans have died, and millions more, including the President, Republican members of this committee, and more than 100 frontline workers here at the Capitol complex have been infected. This pandemic has led to an historic economic crisis, causing millions of workers to lose their jobs without warning, and 12 million Americans have lost their employer-based health insurance. The Senate, I strongly believe, must be and needs to be laser-focused on you, the American people, to help you get through this pandemic. To do so, the Senate urgently needs to pass critical financial relief for those who are struggling because of this pandemic, and many are struggling. People need help. They need help to pay their rent or mortgage. Parents need help putting food on the table. The millions of American workers who have lost their jobs need help making it through the end of the month. And small businesses need help so they don't have to close their doors for good. But sadly, Senate Republicans have rushed to hold this Supreme Court confirmation hearing rather than help those who are suffering through a public health crisis not of their making. As I said yesterday, these priorities are not the American people's priorities. Since President Obama signed the Affordable Care Act into law, Senate Republicans' #1 priority has been to tear it down. And remember, before the ACA, the Affordable Care Act, insurance companies held virtually unchecked power over our healthcare system. They could refuse to cover basic medical expenses like maternity care, like mammograms, like prescription drugs, or hospital stays. Worst of all, if you were sick, they could deny you coverage altogether, and there was nothing you could do about it. Over the last 9 years, Republicans in Congress have tried 70 times to repeal or roll back the ACA in the United States Congress. In 2013, Senate Republicans were so desperate to stop its success that they shut down the entire government for weeks. After President Trump was elected, Washington Republicans spent nearly a year trying to repeal the ACA. But I will always remember the thousands of Americans from all over our country and all walks of life who crowded into the halls of the United States Capitol to require that lawmakers see their faces and understand how they would be hurt if there was a repeal of the Affordable Care Act. Brave activists in the disability community staged sit-ins on the Hill. Seniors protested to keep prescription drugs affordable. Mothers and fathers walked the halls with their children in strollers to show Congress the face of those who depended on the law, and doctors and nurses protested to protect their patients' access to the care they desperately need. Together with many of my colleagues, I joined civil rights and community leaders to speak to the thousands of people who gathered outside the Capitol as they pleaded, as they begged with lawmakers to do the right thing. All of these dedicated Americans demanding that their voices be heard. And they made a difference. They made a difference. History will remember that late night, thumbs down movement when the great John McCain denied Republicans the opportunity to repeal the Affordable Care Act. And now, following a decade of failure, Washington Republicans have realized that the Affordable Care Act is working too well and helping too many people to repeal it without facing serious political consequences. But what are they doing? After suffering the backlash that they provoked by targeting the law in Congress, they decided instead to circumvent voters and try to strike down the Affordable Care Act through the courts. Right now, the Trump administration and Senate Republicans are urging the Supreme Court to strike down the entire Affordable Care Act and all of its patient protections. Republicans are scrambling to confirm this nominee as fast as possible because they need one more Trump judge on the bench before November 10th to win and strike down the entire Affordable Care Act. This is not hyperbole. This is not a hypothetical. This is happening. And here's what you have to know. People are scared. People are scared of what will happen if the Affordable Care Act is destroyed in the middle of a pandemic. There are more than 100 million Americans with pre-existing conditions like asthma and diabetes, heart disease, who know that they could be denied coverage or charged more by insurance companies if Donald Trump is successful in getting rid of the Affordable Care Act. And because of the coronavirus, more than 7 million people have now a pre-existing condition that they didn't have earlier this year. Those who depend on the ACA are afraid of their lives being turned upside down if the court strikes it down. They know what could happen. And Judge Barrett, I will share with you and the American people a list. No protections for pre-existing conditions, higher costs for health care for women and people over the age of 50, young adults kicked off their parents' insurance, more expensive prescription drugs for seniors, insurance companies refusing to cover mental health care, insurance companies refusing to cover maternity care, no free mammograms, cancer screenings, or birth control, insurance companies reinstating annual and lifetime caps, and more than 20 million Americans losing insurance at the worst possible time, again, in the midst of a pandemic, including nearly 2 million Texans, 607,000 North Carolinians, 288,000 South Carolinians, 227,000 Iowans, and 4.2 million Californians. And the pain of losing these protections would disproportionately be felt among the 9 million African American, Latino, Asian, and Native Americans who gained coverage under the Affordable Care Act. But this isn't about statistics. This is about millions of real people living real lives who deserve their government and its institutions to see them and to heed their call. And I know a Republican member of this committee said earlier today that the people who will lose health care are somehow not relevant to this hearing. I disagree. Helping these people is supposed to be why we are all here, why we all ran for office in the first place. And I'm here to fight for people like Felicia Perez. And this is her. Felicia is a writer, a public speaker, and former high school teacher from Southern California who now teaches at the University of Nevada, Reno. She has multiple pre-existing conditions, including arthritis, asthma, and a rare autoimmune disorder that caused tumors that have wrapped around her optic nerve and part of her brain. Her life depends on periodic cancer-fighting infusions that cost $160,000 a year. Felicia is terrified. She knows that without the Affordable Care Act, she could not afford ongoing treatment, the treatment she needs to stay alive. And here's exactly what she said, and I will quote. My life is in the hands of people I do not know, who do not know me, who are essentially telling me I don't matter, that my life doesn't matter, that my health doesn't matter, that the day-to-day quality of my life doesn't matter. And that's really hard. Tragically, Felicia's story is not unique. Her fears are shared by millions of Americans. The Affordable Care Act and its protections hinge on this Supreme Court and the outcome of this hearing. Before being elected, President Trump promised that every justice he put forward would, quote, will do the right thing, unlike Bush's appointee, John Roberts, on Obamacare, unquote. Judge Barrett, 18 months later, you criticized the Chief Justice for upholding the Affordable Care Act when you concluded, quote, Chief Justice Roberts pushed the Affordable Care Act beyond its plausible meaning to save the statute. My question is, how many months after you published that article did President Trump nominate you to be a judge on the Court of Appeals?
Senator Harris, I apologize. I don't remember the timing of that article. I was nominated, I believe my nomination to the Court of Appeals was announced in May of 2017.
That's correct.
But I don't remember when the article came out.
The article was published in January of 2017, so that would have been 5 months later. Justice Ginsburg, whose seat you are seeking to fill, provided the critical fifth vote in a 5-4 decision that upheld the Affordable Care Act. So let's lay this out for everyone who's watching. As I have discussed previously, 1, Republicans have spent a decade trying to destroy the Affordable Care Act. 2, Donald Trump promised to name a Supreme Court justice and Supreme Court justices who would tear down the Affordable Care Act. 3, President Trump is before the Supreme Court right now arguing that it be struck in its entirety. 4, the Supreme Court could be just 1 vote away from overturning the Affordable Care Act and all of its protections, including for everyone who has a pre-existing condition or may ever get a pre-existing condition. In other words, the Affordable Care Act and all its protections hinge on this seat and the outcome of this hearing. And I believe it's very important that the American people understand the issues at stake and what's at play. Judge Barrett, the day after President Trump announced your nomination to the Supreme Court, he tweeted, quote, Obamacare will be replaced with a much better and far cheaper alternative if it is terminated in the Supreme Court, end quote. But in reality, there is no alternative that protects the millions of Americans who depend on the Affordable Care Act every day. The horrifying truth is that President Trump and the Republicans in Congress are fighting to take health care away from the American people in the middle of a pandemic, as I have said. President Trump has said that he wants to protect the American people's health care. But the reality is right now he is asking the Supreme Court to take it away, period. Senator Klobuchar, Judge Barrett, asked you earlier today, but did not receive an answer. Prior to your nomination, were you aware of President Trump's statements committing to nominate judges who will strike down the Affordable Care Act? And I'd appreciate a yes or no answer, please.
Well, Senator Harris, I want to be very, very careful. I'm under oath. As I'm sitting here, I don't recall seeing those statements, but let's see, I don't recall seeing or hearing those statements, but I don't really know what context they were in, so I guess I can't really definitively give you a yes or no answer. What I would like to say is I don't recall hearing about or seeing such statements.
Well, I imagine you were surrounded by a team of folks that helped prepare you for this nomination hearing.
I have
yes. But let me finish if you don't mind.
Oh, I'm so sorry.
Did they inform you of the president's statements and that this might be a question that was presented to you during the course of this hearing?
When I had my calls with senators, it came up. Many of many of the Democratic senators wanted to know about the Affordable Care Act and to satisfy themselves that I had not made any pre-commitments to the president about it.
And so you then became aware of the president's statement, is that correct?
Let's see, Senator Harris, in the context of these conversations, I honestly can't remember whether senators framed the questions in the context of President Trump's comments. Perhaps so. I think from my perspective, the most important thing is to say that I have never made a commitment, I've never been asked to make a commitment, and I hope that the committee would trust in my integrity not to even entertain such an idea, and that I wouldn't violate my oath if I were confirmed and heard that case.
So just so I'm clear, and then we can move on, are you saying that you are now, before I said it, aware or not aware that President Trump made these comments about who he would nominate to the United States Supreme Court?
All right, Senator Harris, what I was saying, I thought you initially framed the question as whether I was aware before this nomination process began. And my answer to that question...
I'm now asking you if you are aware, were you aware before this hearing began?
So you're changing, you're asking me now whether I was aware before the hearing began?
As a follow-up question, I am, yes.
And what I said was that when I had my calls with Democratic senators, this question came up, and I don't recall, but it may well have been that they referenced those comments in the course of those calls. Even if so, that wasn't something that I heard or saw directly by reading it myself.
Senator Leahy asked you earlier today, but I think it bears repeating. Do you think it is important for the American people to believe that Supreme Court justices are independent and fair and impartial? And that is a yes or no answer, please.
Yes, Senator Harris.
A number of my colleagues have asked you today whether you would recuse yourself from cases on the Affordable Care Act. You did not directly answer their questions, and instead you described a process by which that would work or happen. And so my question is, isn't it true that at the end of that process, regardless of that process, that it would be you who ultimately would make the decision about whether or not you would recuse yourself?
That is true, and I can't have you elicit a commitment from me about how I would make that decision in advance. That would be wrong.
Right, and what I've asked you is that is it not correct that that is the process, that ultimately it would be you and you alone that would make the decision about whether you would be recused? You've already opined on the constitutionality of the Affordable Care Act, and that position satisfied the president's promise to only nominate judges who would tear down the Affordable Care Act. And Senate Republicans rushed this process so that you could rule on this very case. The reasonable question about your impartiality will undoubtedly hang over this court's ultimate decision in the Affordable Care Act case if you refuse to recuse yourself. I strongly believe that. Supreme Court justices routinely consider the consequences of their decisions on people's lives. Earlier this year, the Supreme Court ruled against President Trump in his effort to repeal DACA protections for Dreamers. Children, of course, who have arrived in the United States, many before they could talk or walk. Chief Justice Roberts wrote the opinion for a 5-4 majority that included the crucial vote of Justice Ruth Bader Ginsburg. The court rejected the Trump administration's attempt to end protections for Dreamers. Chief Justice Roberts said the administration had not taken into consideration the fact that many Dreamers relied on those protections when they started their careers and businesses, when they served in the military of the United States, when they bought homes, and when they started families. Senator Hirono asked you whether it is appropriate for a Supreme Court justice to consider real-world impacts. But you're a sitting judge now. So my question is, in deciding whether to uphold government action, do you currently consider the consequences of your rulings on people's lives?
Well, Senator Harris, that's part of the decision of every case.
And so you do?
Every case has consequences on people's lives, so of course I do in every case. That's part of the judicial decision-making process.
And would you do that as if you are actually voted on the United States Supreme Court? Would you do that there as well?
Senator, considering how the resolution of a dispute will affect parties, will affect people, is part of the judicial decision-making process, and I will continue engaging in that process to the best of my ability.
So if the Affordable Care Act is struck down, more than 100 million Americans with pre-existing conditions like heart disease, diabetes, and cancer would pay more for insurance or be denied coverage entirely. More than 20 million Americans could lose their health coverage entirely, including nearly 3 million Black Americans and over 5 million Latino Americans who received access to health insurance because of the Affordable Care Act. Insurers will once again be able to discriminate against that more than 50% of African Americans and nearly 40% of Latinos with pre-existing conditions. Insurers will be able to deny coverage to more than 1/4 of Native Americans with conditions like diabetes, heart disease, and cancer. All of this in the midst of a pandemic that is not going away anytime soon. A pandemic that, when age is taken into account, has been 3 times as deadly for Black, Latino, Pacific Islander, and Native Americans. A pandemic that has killed approximately 1 in 1,000 Black Americans, 1 in 1,200 Native Americans, and 1 in 1,500 Latino Americans. Judge Barrett, would you consider the 135 million people who gained protections under the Affordable Care Act when deciding a case that challenges that law?
Senator Harris, if I were to be confirmed and conclude that I was able to sit on the case pursuant to the recusal statute, and then if I heard the case and decided the case, I would consider all the protections that Congress put in place. And as I said earlier during this hearing, the question would be figuring out whether Congress, assuming that the mandate is unconstitutional now, whether that, consistent with your intent, this is Congress's law, would permit this act to stand, or whether the flawed portion of it could just be excised out. And that is a question not of what judges want. It's not a question of the Supreme Court. It's a question of what Congress wanted in the statute. And that is the statute, that you enacted and extended this health care coverage to millions of Americans.
What weight would you give the fact that 135 million Americans with pre-existing conditions are now depending on the protections of the Affordable Care Act? What weight would you give that?
Well, Senator Harris, as I mentioned to Senator Hirono, stare decisis takes reliance interests into account because, as I've said before, stare decisis is about keeping stability in the law. So the law often takes into account reliance interests. I can't really say, sitting here, how they would play in or weigh in this case, because that's part of the legal calculus of the case. So I can't really give you the kind of commitment or pre-commitment that you're asking from me of how I would weigh factors or how I would structure my decision-making process.
I would ask you to consider, if you are confirmed on the court, a credible benefit of the Affordable Care Act, and that a destruction of its protections will have a devastating impact on millions, hundreds of millions of Americans. Judge Barrett, you testified yesterday that Justice Ruth Bader Ginsburg opened the door for many women in law. And I certainly believe and know that to be true as a personal matter. She was a trailblazer for women's equality and gender equity. As a law student, as a teacher, as a civil rights lawyer, and as a second woman ever to sit on the United States Supreme Court, Justice Ginsburg broke many barriers for women across the country. I believe, all fondly remember her as a person who had patience. She had the will and the vision to make our country a more equal place and a more just place. And one of the things she fought for was a woman's right to control her own body and to make decisions about her own body and health care and reproductive choices. The Constitution of the United States protects a woman's right to choose whether or when to become a parent. And it protects a woman's right to choose abortion. Women of color, immigrant women, women with low incomes, and women in rural areas face significant barriers when attempting to access birth control, cancer screenings, and comprehensive reproductive health care. Moreover, anti-choice activists and politicians have been working for decades to pass laws and file lawsuits designed to overturn Roe and the precedents that followed. The threat to choice is real. Just last year, the court heard a case that gave it an opportunity to revisit and overturn its abortion precedent. In a case called June Medical Services, the Supreme Court struck down a medically unnecessary restriction that would have closed all but one abortion clinic in Louisiana. Chief Justice Roberts agreed with the court's 4 liberal members that the court was bound by its own precedent to strike down the Louisiana law because it was virtually identical to a Texas law that the court ruled unconstitutional in 2016. As a result, women in the state were able to receive the full range of reproductive care. But Chief Justice Roberts wrote his own separate opinion in the case to make clear that in the future he could not be counted on to uphold a woman's right to choose. Justice Ginsburg provided the critical 5th vote to strike down the unconstitutional abortion restriction in June Medical Services. So we must be honest about the impact of her passing and the impact it will have on the court's decisions in cases regarding women's access to reproductive health care. Now, my Republican colleagues have said that there is a minimal chance that the Supreme Court will overturn Roe. But back in January, 39 Republican senators, including 10 members of this very committee, signed their names to a Supreme Court brief that asked the court to, quote, take up the issue of whether Roe should be reconsidered and, if appropriate, overruled. So let's not make any mistake about it. Allowing President Trump to determine who fills the seat of Ruth Bader Ginsburg, a champion for women's rights and a critical vote in so many decisions that have sustained the right to choose, poses a threat to safe and legal abortion in our country. After all, President Trump said that overturning Roe v. Wade will, quote, happen automatically, in my opinion, because I am putting pro-life justices on the court. Judge Barrett, several times today, you have quoted Justice Ginsburg's testimony about not making predictions in future cases. However, she was far more forthcoming at her confirmation hearing about the essential rights of women. In 1993, Justice Ginsburg's confirmation hearing shows that she testified that, quote, the decision whether or not to bear a child is central to a woman's life, to her well-being and dignity. It is a decision she must make for herself. When government controls that decision, for her, she is being treated as less than a fully adult human responsible for her own choices. Then Judge Ginsburg went on to say, quote, it is essential to women's equality with man that she be the decision maker, that her choice be controlling. If you impose restraints that impede her choice, you are disadvantaging her because of her sex, unquote. Now, Justice Ginsburg did not tell the committee how she would vote in any particular case, but she did freely discuss how she viewed a woman's right to choose. But Judge Barrett, your record clearly shows you hold a different view. In 2006, you signed your name to an advertisement published in the South Bend Tribune. It described Roe v. Wade as, quote, an exercise of raw judicial power, and called for putting, quote, an end to the barbaric legacy of Roe v. Wade. You signed a similar ad in 2013 that described Roe as, quote, infamous, and expressed opposition to abortion. also in 2013, you wrote an article about Supreme Court precedent in which you excluded Roe from a list of well-settled cases that you said, quote, "No justice would overrule even if she disagrees," suggesting, of course, that you believe Roe is susceptible to being overturned. On the 40th anniversary of Roe, you delivered a speech in which you said that the court's recognition of the right to choose was, quote, "created through judicial fiat," rather than grounded in the Constitution. And during your tenure on the Seventh Circuit Court of Appeals, you have been willing to reconsider abortion restrictions that other Republican-appointed judges found unconstitutional. As the Senate considers filling the seat of Justice Ruth Bader Ginsburg, who was straightforward enough in her confirmation hearing to say that the right to choose is, quote, "essential to woman's equality," unquote, I would suggest that we not pretend that we don't know how this nominee views a woman's right to choose and make her own health care decisions. Mr. Chairman, I ask unanimous consent that the following 3 documents be entered into the record: a letter opposing Judge Barrett's nomination from the NAACP, a statement opposing Judge Barrett's nomination from the Planned Parenthood Federation of America and Planned Parenthood Action Fund, and a report opposing Judge Barrett's nomination from the NAACP Legal Defense and Educational Fund.
Without objection.
Thank you, Mr. Chairman.
Thank you. Thank you very much, Senator Harris. Senator Kennedy.
Mr. Chairman, I have a letter here in support of Judge Barrett, signed by 281 graduates and former classmates of hers at the extraordinary St. Mary's Dominican High School in New Orleans. And I'd like to offer that into the record.
Without objection.
You tired, Judge?
I'm looking forward to the end of the hearing today, I must admit.
Me too. I'm still going to ask you questions.
I was hoping you'd say you were going to yield your time, Senator.
No, ma'am. A lot of my colleagues, and you as well, have talked about the oath that you will take if you're confirmed and sworn in as an Associate Justice of the United States Supreme Court. What's in that oath? What's it say?
Well, that oath requires a judge, I've taken the oath as a judge, to do equal justice to all, without fear or favor, regardless of wealth. To fairly apply the law is what it boils down to not give preferential treatment or express bias, in plain terms.
It says you'll administer the law in an impartial manner without regard to your personal feelings, doesn't it?
Yes, it does, Senator.
It says you will support and defend the Constitution, doesn't it?
Mm-hmm.
Pretty serious oath, isn't it?
It is.
Are you going to take that oath and affirm it if you're confirmed?
Yes.
You're not lying.
I'm not lying. I took that oath before I began as a judge on the Seventh Circuit, and I have not violated that oath, and I would take it again, and oaths are serious to me.
Well, now, Senator Harris just called you a liar. She said that if you take that oath, you'll be lying, that you've already made up your mind how you're going to vote on some cases, particularly dealing with abortion and the Affordable Care Act. Let's just cut to the chase. She said you're a liar. Are you a liar?
I am not a liar, Senator Kennedy.
All right, I want you to tell me again, look me in the eye, you're in front of God and country. If you take that oath, will you mean it?
I will mean it. If I take that oath, I will mean it.
You swear to God?
I swear to God. And I have sworn at the Seventh Circuit, and I meant it there too.
You'll never break that oath?
I will not break that oath.
No matter what your personal feelings are?
No matter what my personal feelings.
No matter what your religion is?
No matter what my religion is.
So when Senator Harris and her colleagues say you're a liar, they're wrong.
They are.
All right, let's see. You're 48 years old. You're an honors graduate of Rhodes College, an extraordinary liberal arts school. You're an honors graduate of Notre Dame Law School. You clerked for 2 distinguished federal judges. You've been a chaired law professor. You're a devout Christian. You've raised 7 children. I don't mean to wax too metaphysical here, but do you have personal values as a result of this?
I would hope that no one would consider me to be nominated for anything if I had no values.
Do you have personal opinions?
Of course, I have personal opinions.
Do you have principles?
I have principles. It wouldn't be fit for office if I didn't.
Let's suppose that we had a nominee appear before us. It happens to be a man in my hypothetical. And he said, I've been nominated for a federal judgeship, and I finished law school, but I hadn't cracked a law book since law school, since civil procedure. And I don't have any opinions. I don't have any principles. I don't read newspapers. I don't even read the news. I hadn't read a book since law school. I'm like Bluto in Animal House. I'm just fat, drunk, and stupid. I think the Germans are the ones who bombed Pearl Harbor. I think climate change, I think it didn't cause the Cold War. But I'm your guy, because I don't have any value. I'm a blank slate. And that's what is required, isn't it? For me to be impartial? Do you think we ought to confirm that gentleman?
Well, then Chief Justice Rehnquist wrote an opinion on this issue and addressing recusal, and he said basically that if someone reached middle years, which one is basically middle-aged if one would be a justice on the Supreme Court, and had a mind that was a blank slate and had no opinions, then one would question such a person's fitness for office.
Well, my colleagues seem to think you're only qualified if you're dumb, if you have a blank slate, if you've never thought about the world. You've thought about the world, haven't you?
I indeed have.
Have you thought about the social problems facing our world?
I have thought about social problems facing our world.
Economic problems?
Sure.
I don't want to know what your feelings are, but have you thought about the merits and or lack thereof of nuclear energy?
No, I really haven't.
How about
delved
affirmative
deeply into
action?
that one.
Have you thought about that just as a
Sure.
subject?
Yeah,
Yeah.
I've thought about it.
How about climate change? I mentioned climate change. Have you read about that?
I've read about climate change.
And you have some opinions on climate change that you've thought about?
You know, I'm certainly not a scientist.
I'm not saying you are.
I mean, I've read things about climate change. I would not say that I have firm views on it.
How about, have you thought about the merits of a flat versus progressive income tax?
I have thought fleetingly about that.
Yeah.
These aren't things that I'm not a tax lawyer or an
I'm not
economist.
trying to trap you.
Sure.
How about Justice Kagan? I've always been impressed with her credentials. Graduate of Princeton, did an MPhil at Oxford. I think she went to Harvard Law, was dean of Harvard Law School.
She was.
You think she's thought about the world?
I'm sure she has, and I too am very impressed with Justice Kagan.
Yeah, me too. You think she's thought about climate change and has personal feelings?
I don't know. I mean, probably, but I can't really say what, Justice Kagan has thought or not about.
Okay. Now, you have personal feelings about abortion, don't you?
I do have personal feelings about abortion.
Do you have personal feelings? Have you ever thought about how we deliver health care in this country?
I do, but Senator Kennedy, one of the things about the judicial role that I've repeatedly emphasized in the hearing today is that I've got personal views and personal feelings on a range of matters, just like every human does, and just like every judge or justice on the court does.
Well, that's what I'm getting at. Now, my colleagues say, and Senator Harris said, that even though you have a personal opinion about abortion, that you will violate your oath to put aside those personal feelings and fairly decide abortion cases. Is that true?
That, I gather, was the thrust of what she was saying to me, yes.
Is she right?
No, she's not right.
And let's talk about the Affordable Care Act. It's going to, California v. Texas. You've thought about the delivery of health care.
Yes,
You got 7 children.
spent a lot of time.
You've probably been to an emergency room.
Yes.
You formed opinions about the delivery of health care. Are you going to, should you recuse yourself?
Well, Senator Kennedy, any opinions that I have, everyone has opinions. Any opinions that I have are just not relevant to the resolution of a case.
Right.
Affordable Care Act case or anything else. And a lot of my opinions, are not ones that are expert, for example, in scientific matters or taxing matters. I mean, might have dinner table discussions, but I don't purport to be an expert in any of those fields.
Well, I'm going to hit this on another lick now because this is serious.
Okay?
Some of my colleagues and Senator Harris say you're lying. Are you lying?
I'm not lying.
Are you going to take that oath and abide by it?
Yes, sir.
Will you ever break that oath?
I will not break that oath, Senator Kennedy.
Okay. Now, one of my colleagues, I don't remember which one, said that because President Trump appointed you, or nominated you, rather, that if there's a case that happens to go before the United States Supreme Court after you're confirmed dealing with the upcoming election, they ask you to recuse yourself. Remember that question? Mm-hmm. And you said you would go through the process.
Of determining
Right.
the recusal question.
But you
yes.
didn't commit to recusing yourself until you, in one way or the other. You said you'd go through the process.
I said I would go through the process. I committed to going through the process of determining whether to recuse, but I did not commit to it.
Now, President Trump nominated Judge Kavanaugh, now Justice Kavanaugh, the Supreme Court. Mm-hmm. Did anybody ask him to recuse himself when the president's tax returns were before the court?
I don't know.
Justice Gorsuch was nominated by President Trump and confirmed by the Senate. Did anybody ask him to recuse himself when President Trump's tax returns were before the court?
I don't know if any motions were filed.
Do you know who Paula Jones is?
I do.
Okay. She sued the President of the United States, didn't she?
She sued President Clinton.
Yeah. Clinton v. Jones. Famous case. President Clinton nominated Justice Ginsburg and Justice Breyer to the United States Supreme Court. They heard that case. Did anybody ask that Justice Ginsburg recuse herself because President Clinton nominated her?
I don't know if any motions were
You
filed.
think she should have?
Well, that's not something I would opine on. I'm sure that she discharged her oath to consider the question.
Did any of my colleagues ask that Justice Breyer recuse himself from hearing Clinton v. Jones because President Clinton had appointed him?
I don't think that's come up in the...
Yeah, I don't think so either. All right, I want to finish this housekeeping because I want to talk about the law. I want to give you a chance to respond to something. Some butthead professor at Boston University says that because you and your husband have 2 children of color, that you're a white colonist. The implication is that you're a racist and that you use your 2 children as props. Do you use your children as props?
Senator Kennedy, it was the risk of people saying things like that, which would be so hurtful to my family, that when I told Senator Graham this morning that my husband and I had to really weigh the costs of this, it was saying deeply offensive and hurtful things that are not only hurtful to me, but are hurtful to my children, who are my children, who we love, and who we brought home and made part of our family. And accusations like that are cruel
Yeah, they are, aren't they? How low can you go? I didn't want to ask that question when your kids were here. I'm sorry I have to go through that. Okay, let's talk about the law. Let's suppose, I'm not going to ask you how you're going to rule on a case.
Okay.
And you couldn't answer anyway. You'd violate the judicial canons of ethics. I don't know what would happen to you, but it'd probably be pretty bad. Because you're a sitting judge. You're on the Seventh Circuit.
Judge.
But let's suppose that a litigant, let's suppose Congress passed a statute making distinctions on the basis of wealth.
Okay.
And somebody filed a lawsuit and said their argument is that wealth is a suspect classification. How are you going to analyze a case like that? Tell me how you'd analyze it. I just want to know how you think.
Sure. Well, if someone argued that wealth was a suspect classification, I assume you're saying that they're probably making an equal protection claim.
Yep.
So I would go to precedent would be the first source because the Equal Protection Clause has a rich body of precedent under it that identifies suspect classes. For example, classes drawn on the basis of race are suspect and they get heightened scrutiny. So I would look through Supreme Court precedent to determine whether there was anything relevant to the question of whether wealth was a suspect class or not.
Okay. You're familiar with San Antonio School District v. Rodriguez?
My mind's getting mushy this many hours into the hearing, so you might need to
Well,
refresh
let me put it another way. Wealth's not a suspect classification, is it?
I am not aware of a case saying that wealth would be a suspect classification.
Well, here's what I don't understand. I've always wondered about this. Okay, remember, this is Congress passing the statute, not some state. So the litigant is not pursuing this under the 14th Amendment. He's pursuing it under the Fifth Amendment. And he's making a substantive, he's making an equal protection argument, not substantive due process. That would be a fundamental right. Where does the Fifth Amendment mention equal protection?
Well, the Fifth Amendment has a due process clause, but
I know.
the Fifth Amendment doesn't. But
the 14th Amendment has a due process clause and an equal protection clause, but which applies to the states. But the Fifth Amendment clause, Fifth Amendment to the Constitution has a due process clause, but it doesn't say a word about equal protection.
that's true, but the Supreme Court has interpreted it as applying the equal protection clause as well against the federal.
How can they do that if the words aren't there?
Well, there was a case, I believe the case in which the court addressed this was the one that addressed the constitutionality of segregation in the District of Columbia, which is governed by federal law. And the court said the same principle applies. And so essentially the reasoning of Brown applied there.
Okay, I remember that. All right, let's talk about Heller. Senator Crapo talked about it a little bit. I went back and took a look at Heller. Scalia wrote, you know this better than I do, Scalia wrote the majority opinion. I think Stevens wrote the leading dissent. And it was interesting, they both took an originalist approach, and I went back and looked it up. Scalia relied on, tell me what an originalist approach is again. I know there are different strains, but what's your strain?
Sure. You take the Constitution, so in Heller, for example, what Justice Scalia did, and this is an example of originalism, he went back to the time of the ratification of the Second Amendment to figure out whether when that amendment was ratified, whether that right to bear arms was considered to be an individual right or one that was a civic right.
Excuse me for interrupting, but considered by whom?
Considered by the people.
The people.
By the people at the time, not in the minds of the framers, but by the people.
I went back and looked. I'm sorry.
No.
I've had a little coffee. I'm kind of jacked up. I went back and looked it up. Scalia, he relied on, to reach his opinion, he relied on founding-era dictionaries, founding-era treatises, English laws, American colonial laws, British and American historical documents, colonial-era state constitutions, post-enactment commentary, all on the Second Amendment. And then here comes Justice Stevens. He's dissenting. He relied on, in his dissent, he relied on linguistic professors, an 18th century treatise on synonymous words, on a different editor of one of the same colonial era dictionaries on which Scalia relied. So they both went back and looked at history. Here's my question. Since when did justices become historians? Let me put it another way. If this is the way we're going to interpret the Constitution, by looking at history, why do we need you guys? Why don't we just hire professional historians?
Well, so justices and judges interpret laws, and we interpret texts. And if texts are unclear, you have to figure out what their meaning is, right? And so with the Constitution, sometimes that does require delving into history. One point that I think is worth, Justice Scalia would make this point, that the alternative is, let's say you have an amendment like the Second Amendment's right to bear arms. If it's not evident, looking at it, whether it's an individual right or a collective right for the sake of the militia, one approach would be to rely on the moral judgment of the justice, say whether they think it's a good thing or a bad thing for the common good for people to have that individual right. And of course, judges aren't moral philosophers either. So when you're interpreting a text and you need to turn to something, what judges know is words and what judges know is law. And so having them go back and look at the history, those are familiar things to lawyers. And they're things that all justices consider. As I said earlier in the hearing, all justices do consider the history and the original meaning. And that's been true since the beginning of the court itself. Throughout the 19th century, this idea of originalism isn't new. So throughout the 19th century, throughout the 20th, the court has resorted back and looked to see what the original meaning is. It's just that I would say the difference between those who identify themselves as originalists and those who just consider it is the amount of weight that they give it. So all judges have to be skilled in doing it to a degree because everyone agrees that as a matter of law, the original meaning matters.
Tell me what the Ninth Amendment means.
Well, the Ninth Amendment was once famously described by Judge Bork as an inkblot. The Ninth Amendment has not been fleshed out in litigation. I don't think it's an inkblot, just to be clear. But it's not one that there's a whole lot of case law on.
I want to talk to you a little bit about originalism, or at least your strain of originalism, and how it's related to textualism, and how it's different from purposivism. Did I understand you correctly to say that in originalist pleas that judges have to follow the original public meaning of the Constitution? Correct. The original public meaning.
Public meaning as distinguished from private intentions of those who drafted the document.
Okay. Does this mean, when you say original public meaning, whose meaning? The average person in the community at that time?
Well, we would say informed observers. So
I'm sorry?
I would say informed observers, so those who were familiar with the debates, which is why looking at the state ratifying conventions, debating the Constitution can be a fruitful source.
Is it okay, I know it's not okay to do it exclusively, but is it okay to consider what the drafters thought?
Sure, and James Madison's notes from the Constitutional Convention are a source that the court routinely looks to in trying to determine original meaning. It's just that it's not conclusive.
What's the dimension of time? I mean, at what point in time do you look at the original public meaning?
Well, I would say there's some debate about that because, you won't necessarily have all the evidence you need right from 1791, which is when the Bill of Rights, as you know, was ratified. I think looking at the evidence from before that, so we see that in Heller, that Justice Scalia looked at how people understood that right all the time leading up to the ratification of the Second Amendment because it cast light on the language people were speaking at the time and how they would have understood it. So you definitely can look some before.
Okay, excuse me for interrupting, but my clock's running. Okay, Is it, if you look at 10 years after the Constitution was adopted, is that okay? How about
Well,
20?
I think all of that can be relevant evidence. I think the farther that you get away from the ratification of the document, then I think the dicier it gets, because we might say that, well, between 1791 and, 1801, that people had roughly the same understanding, but of course, as time passes, then attitudes can change. So I wouldn't say that there's a firm cutoff, but I think it's clearly the case that the evidence that's closer to the time is the most probative.
Okay, what's the difference between originalism and textualism?
Well, textualism is how we describe a method of interpreting statutes. So it actually, in many respects, is kind of like originalism applied to a statute. So it would say you take statutory text, for the Clean Water Act, or, the make up one, the Amy Barrett Act passed today. You look at what the words would have meant to those who read the act at the time and informed observers of the debate.
So you're looking at the ordinary meaning of the words.
You're looking at the ordinary meaning of the words,
The plain meaning of the words.
the plain meaning of the words.
What if they're unclear?
Well, there are a series of canons of interpretation that judges employ to decipher language. They're like linguistic tools. Like sometimes a list means the expression of some things implies the exclusion of
I'm
others.
familiar with all those. You know them better than I do. But if the statute's unclear, if there is no ordinary meaning, can you look at legislative history?
Generally, I think that legislative history is a less fruitful source because generally when people make arguments about legislative history, they tend to be less about what a word meant and how a statute would apply to a certain circumstance, which is a little bit different.
But if it's ambiguous, you can look at legislative history as a last resort.
You can look at legislative history to determine whether there was a particular understanding of a word or a phrase. But I think it would be, in most cases, inadvisable to look at legislative history to make a determination, and certainly not to treat it as binding, about how a statute would apply to a particular set of facts.
Okay, well how ambiguous? A lot of textualists say if the statute's ambiguous, if it's unclear, then I can consider secondary sources. How ambiguous does it have to be? 51%? 65%? How do you know how ambiguous?
Well, it's not
It
a
has to be.
precise, it's an art, not a science, I would say, Senator Kennedy. You exhaust all the canons of interpretation, and that includes even ones that are not the grammatical canons, but are like the avoidance canon. You run through all of those, and then you look at the structure of the statute. And I think deciding when something crosses the threshold and becoming ambiguous, so you can consider canons like the rule of lenity or the avoidance canon, that's a very difficult question, and it's part of the debate about the Chevron doctrine.
Okay. You familiar with the term purposivist?
Yes.
Okay. I think, you correct me now, a purposivist says, look, I look at the statute, even if it's clear, I can still look at secondary sources and try to figure out what problem the legislative body was trying to solve.
That is so, yes. A purposivist would say that to be faithful to Congress would be to be faithful to the purpose of the statute.
Yeah.
And that sometimes the text doesn't align exactly with the purpose, and that in that circumstance, the judge should go with the purpose rather than the text.
Now, everybody's a textualist now, or an originalist. But really, aren't a lot of our textualists really purposivists? In other words, they go, well, I looked at the language of the statute, it's unclear. So I checked off the originalist, or rather textualist box, and now I can just go look at what problem Congress is trying to decide and do whatever the hell I want to do.
There has been some academic commentary, definitely in the last 5 or 10 years, saying that that's become kind of the new strain of textualism. You might know the case Holy Trinity.
Yeah.
Yeah, calling it the new.
It's been overruled, though, hasn't it?
Holy Trinity, you mean its approach to statutory interpretation and its
yes.
endorsement?
Yeah.
No, it's never been overruled, but it's fallen out of favor. But this idea of doing what you're saying, stretching to find ambiguity in text, the argument that some make is that it's kind of a new form of Holy Trinity, because rather than saying that the text is clear but inconsistent with the purpose, the argument is that the purpose renders the text unclear.
All right, let me ask you a couple more. I want to talk about a state constitution. In Louisiana, we had a constitutional convention in 1973. We wrote a new state constitution. And we recorded everything. We got, I think, 14 volumes of transcripts, committee reports, anything you could possibly want to know about the drafting of the 1974 Louisiana Constitution. You're an originalist. Are you telling me to just throw all that stuff out?
No, those things would be the equivalent of looking at James Madison's notes from the Constitutional Convention or the state ratifying conventions. All those things shed light on what Louisianians were thinking when that Constitution was drafted and ratified.
Okay. Mr. Chairman, I want the record to reflect that I landed this plane with 26 seconds left.
So noted. Thank you very much, Senator Kennedy. Senator Blackburn.
Thank you,
you,
Mr.
Judge.
Chairman.
Thank you, Senator.
I have 3 letters to submit, one from Penny Nance, the CEO of Concerned Women of America, on behalf of that organization, Amy Kramer, chairperson of Women for America First, on behalf of their organization. They're both in support of Judge Barrett, and then a letter from Tennessee Secretary of State Trey Hargett, who is applauding her record on textualism and stands in support of her nomination.
Without objection.
Judge Barrett, you have been a trooper, and so we're going to do a little bit of loose end tying up and then get you on your way. And we appreciate the commitment that you have made. And Jesse, I tell you what, my hat is off to you. You have just been great to be here today and to stand right with her. I tell you, I wish my husband were here. We were talking a little bit earlier today about when I called him, about how you have been right here, hardly leaving the chair the entire time. And we appreciate that. My husband has said he's someday going to write a book, and he's going to call it, I Carried Her Purse. Because we couldn't do what we do without supportive spouses. First thing I want to say, and Senator Ernst touched on this, our colleagues across the aisle have spent a lot of time talking about COVID relief and the importance of that for health care and for people that are suffering. They have the opportunity. We can put our bill back on the floor. They each chose to vote no, every single one of them, on additional PPP, unemployment insurance, money for testing and vaccines, getting schools open, and liability protection so that businesses can open. So we would be very pleased to have that bill back on the floor and to pass it to get needed relief to the American people. The second thing I want to touch on, I think there's been a little bit of confusion with some of the comments that were made. It's important to note that abortion is not mentioned in the U.S. Constitution.
The word abortion does not appear in the U.S. Constitution.
That is correct. And Roe versus Wade is not an amendment to the Constitution.
Roe versus Wade interprets the 14th Amendment of the Constitution and locates the right to terminate a pregnancy in the liberty, in the due process clause, the liberty interest.
Correct. I think that from some of the comments from some of our colleagues, there has been confusion about that. The next thing is Senator Whitehouse kind of came at you saying you had never tried a case. And I think it is important to note that Justice Kagan had never tried a case. And we want to have that. She's been mentioned several times today. So as a point of clarification, we would want to mention this. One thing that we have heard a good bit about at this committee, and some of our colleagues chose to mention this yesterday, is that Republicans don't nominate enough female judges. But when we nominate a highly qualified woman for a Supreme Court vacancy, what is the very first thing they do? They turn their attack machine on. And then they start into the politics of personal destruction. And they attack you for not fitting into the paradigm of the left, because you're pro-life, pro-family, pro-religion. And we have seen this happen with other judges that have come before us. Judge Naomi Rao, Wendy Vitter, they have been criticized. And if you don't buy into this agenda of the left, if you're female, then they act as if you're not a real woman. And I will tell you, quite frankly, they do not believe that all women deserve to have the opportunity to have a seat at the table. It's only certain women, and we have seen their liberal narrative play out today. Senator Hirano really tuned up on this when she suggested that you, of all people, would not support women in the workplace. And I will tell you this, as a woman who has worked in the private sector and then in public service, when comments like that are made, it discourages all women from trying to step forward and trying to take the skills that they have developed in one area of their life and then use it as an opportunity to serve their nation, to serve their community, because they don't want the liberal attack machine pointed at them. And I will tell you, quite frankly, it is so discouraging to me to see groups on the left say, we want diversity, but let that diversity come from a woman who is on the political right. And it's like their heads explode. They do not want that as a part of the conversation. What they prefer to have is that very narrow, liberal viewpoint. And I look forward to the day when that will stop, because all women deserve the opportunity to rise. And, you know, I find it so interesting that they don't want to support women from the political right, because we do not submit to the leftist agenda. We won't submit to that. So then free thinkers end up being called bad women and traitors to our gender and other disparaging comments that are out there. And you have endured some of these pretty extraordinary revelations today, many of which have involved accusations that you're part of some sort of backroom conspiracy to rig the system against the American people, and that your record as a judge is somehow frightening and is going to cause a panic. But I have a feeling that this isn't the first time you have heard such rhetoric or been subjected to such rhetoric by a group of your peers that have probably tried to hold you back because of your personal beliefs. I think that most of us that come from the political spectrum on the right have endured that. A professional organization that would have been nice to join, but because you're pro-life, you can't. Opinion not wanted, participation not wanted, because you're pro-religion. Pro-family, opinion not wanted, do not apply for admission. And this is the kind of wrong-headed perceptions that need to stop. It is not uncommon for women who practice their faith or who hold pro-life views to endure this, especially in a professional context. And that is what we have seen the left throw at you today. And I find it so interesting that they have tried to use this focus to evaluate your professionalism as a judge, doing to you exactly what they say they despise. Interesting take. I'd like to hear a little bit more about the intellectual and personal discipline you mentioned during Senator Lee's line of questioning. Let's go back to that. You said that discipline is required when resisting the urge to exercise your own will when deciding how to rule on a case. So talk for just a second about that. Why it's important to stay true to your basic constitutional statutory framework rather than favoring the living Constitution approach.
Well, Senator Blackburn, I think as it came up with Senator Lee, and I know with Senator Sass and Senator Hawley too, that judges are not policymakers. And we live in a pluralistic society where we have lots of different views on lots of different matters, as Senator Kennedy was pointing out. And so in a pluralistic society, I may approach a particular problem, let's say it's a problem of constitutional law, and I may really feel like the result I want is one way, but I'm just one person. And there are surely other people in America, other people on the bench, who would see the best resolution going a different way. So who am I, or who is any judge, to say that their result, like, oh, just this once or just this time, I'm going to reach the result that seems the best, even if it runs against the law that the people have ratified. And so it would be wrong because, I don't think people, I think I said earlier, want to live under the law of Amy. We have the United States Constitution, and that's what judges should be faithful to. I see Senator Kennedy don't want to live under the law of Amy.
Well, but I think probably the law of Amy prevails at the Barrett household over those children.
50-50.
I used to tell my children, and my son's birthday is today, and we were chatting earlier, and we were laughing about how when I wanted them to do something that they didn't necessarily want to do, I would remind them that I was the chief mama in charge. So it was something that was going to happen. Let me touch just a second on Obamacare, because our friends across the aisle have seemed to express just a deep concern about a case that is coming up on November 10th, the severability clause, and how this would take Obamacare down. Again, this goes into their fear-mongering and causing panic, and we know that, because it's not about the ACA case that is scheduled for November 10th. This is all about their concern that a constitutionalist judge on the Supreme Court just might get in the way of their push to implement government-run health care, to do a socialized medicine plan, or to do the Green New Deal, or to do statehood for D.C. Their wish list of items that they have. But we do, for the record, need to clean up the numbers that are around this. We've heard some wild numbers get thrown around today when it comes to the ACA. There are right now 8.3 million Americans enrolled in the ACA Marketplace Exchange, enrolled in Obamacare. So, and what they're doing is blowing that number up. And they have tacked on the entire individual market and added Medicaid and Medicare to get to their number that they are saying is 150 million Americans are going to lose their health care. What they're not saying is there are 153 million Americans that are in the private health care marketplace. So if they got their way, every one of those individuals in that private health care marketplace would lose their health insurance. So our goal is to make certain that all Americans have access to affordable health care. And I think it's a bit disingenuous the way that 8.3 million is the number that comes to us from CMS and HHS. And then, as I said, they're blowing that up by adding in the entire individual market and Medicaid and Medicare, and forgetting to mention that there are 153 Americans that have a private health insurance. My colleague from California would really like to have people believe that your sole mission in life is to overturn the ACA, and you have stated that you are not on a mission to overturn the ACA.
I am not Senator Blackburn, and I have no mission and no agenda. Judges don't have campaign promises.
That's a good thing. And they've made much about a letter that you signed opposing a contraceptive mandate and an article that you wrote criticizing an interpretation of the ACA as a tax. Mm-hmm. But I had a very interesting conversation today. I actually did a Facebook Live with one of your former students who had written an op-ed for Real Clear Politics, Chase. Mm-hmm. And Chase Giacomo said one of the things he appreciated about you is that you made your students think. And I think that is a wonderful trait for a judge, because what you did was to cause them to get into problem solving. And at a time when we live in a cancel culture, that is a very positive thing to have students do, to cause them to think. So we really appreciate that. And I know that you've stated that you're going to put aside personal opinions and abide by the Constitution when it comes to addressing all of the cases that would come before you. Let's move on. Senator Sass went to the Fourth Amendment with you, and I want to touch on this pertaining to electronic searches and surveillance. And the Fourth Amendment is so important for safeguarding the privacy of our citizens and our data from unreasonable searches and seizures. And so many Americans are doing so much of their life online. And I think it is imperative that Americans have the ability to protect their virtual you, which is their presence online, their data, their transactional life. And now, for so many people, it is the way they're working. And as you said at the White House ceremony, the Barrett E Academy, of which you all co-principled, people are going to school online. And there was a case, Carpenter versus U.S., and it outlined just how far the Constitution protects searches of electronic evidence. It was a 5-4 decision, and the court ruled that law enforcement must obtain a warrant in order to track a person's cellular location information beyond 7 days. Justice Thomas and Gorsuch both dissented, and Justice Gorsuch objected that the majority's reasonable expectation of privacy standard was not faithful to the Fourth Amendment text. Instead, Justice Gorsuch reasoned the Fourth Amendment protects only those searches included in the original text, searches of persons, houses, places, and effects. Some critics of originalism complained that today's laws should not be governed by the dead hand of the past. Can you explain to us how the Fourth Amendment can still govern the modern world's searches and seizures, and how will it continue to apply to emerging technologies that the founders never could have imagined?
Sure. So I think as a general matter, the Fourth Amendment protects against unreasonable searches and seizures. And it doesn't mean that it protects only the kinds of searches and seizures that those who lived at the time of the adoption of the Bill of Rights could have anticipated. So surely they couldn't have anticipated the internet or cell phones or, airplanes for that matter. But one can reason from the kinds of privacy protections that were in place in 1791 when the Fourth Amendment was ratified to see if the search of modern technology now is analogous to it. So one example is the Kylo case. Justice Scalia wrote that opinion, and that's a case where law enforcement had used an infrared detector to see if someone was growing, I think it was marijuana on the inside, and they could use the infrared to see if it lit up if people were using heat lamps essentially inside. And Justice Scalia said that, yes, that was a search, that the Fourth Amendment did apply and the police had to have a warrant. Even though that technology didn't exist at the time, it was the same kind of invasion into the home. And so it didn't matter that, infrared machines were not in the contemplation of the generation that ratified the Fourth Amendment.
Okay, and then is there a difference between searching for data via a device that is in a person's possession and searching for, say, data on the servers that are hosting?
Let's see. So that would be a question I probably can't answer. In addition to the Fourth Amendment, there would also be statutes that, govern how much data one could mine. So that would be one of those legal hypothetical situations that I wouldn't be able to answer in the context of the hearing.
All right. Let's end it at that so that you can get out of here. There are a couple of things that tomorrow we're going to have time, and we will talk about a couple of those other questions, campus free speech, executive overreach, a couple of other things we'd like to have on the record. But thank you very much for your patience and for your desire to serve.
Thank you, Senator
Thank you,
Blackburn.
Mr. Chairman.
Thanks, Senator Blackburn. I'd like to echo what Senator Blackburn said. You've been very patient, very poised, and I really appreciate the way you've handled yourself today. To the committee, I quite frankly think this has been a good example of what can be in the Judiciary Committee. Challenging questions on things that matter to people in a way that you can leave the arena saying, well, that worked pretty well. One more day, 20 minutes apiece. See you at 9 o'clock.
How important is this to Republicans to get this nomination through committee and out here through the floor in order to hold the majority come November?
Well, I look at it, I think it's important for the country to see the nominee. I've been very impressed with her. The vacancy has been open due to the tragic loss of Justice Ginsburg. I think President Trump has chosen an outstanding woman in the law, and we're going to fill this vacancy. We'll be voting October the 22nd. If things continue the way they've been going, I think we'll have a good vote for the judge on the floor.
Is this going to help Republicans?
You know, I really don't. You know, I guess it depends on what state you're in. I think it helps to see somebody highly qualified going onto the court. And I just want to stress this. You know, I'm a Republican conservative man. Republican conservative women have a tough time sometimes. And I just want to thank President Trump for creating a seat at the table for somebody who is unashamedly pro-life, somebody who embraces their faith, but also understands the difference between their personal views and judging. To me, in this process, no one even thinks to ask the pro-choice nominee anything about would you do this or would you that. So I'm glad that a unashamedly pro-life person will be nominated for the court, but most importantly, I hope people in the country know that her personal feelings will not dictate how she decides. On the Affordable Care Act, the issue of severability, I think it's pretty clear to me that the doctrine of severability suggests that you save a statute if possible. I don't know how she's going to rule, but it's clear that she understands that area of the law. And I'm going to ask her a little more about that because she's not trying to give us any hints or predictions, but I just want people to understand how the law works. If you're a conservative, you need to understand that the conservative position is to have courts uphold legislative enactments when it's possible, not strike them down.
Senator, given that we're 3 weeks away from Election Day, how much do you think that her performance today will affect your efforts to try to keep the Senate majority, especially when the president himself is dragging?
I can just say in South Carolina, people like conservative judges, that there's a preference for conservative Supreme Court justices. I think that's just a fact of how our state stacks up. It'd probably be different in different states, but my takeaway is if you're a young woman, conservative young woman, I hope this gives you some hope that America is changing, that everybody can come to the table, the entire slice of the American pie.
Do you feel like that you guys may get any backlash for moving ahead with this nomination?
It's hard to say how people, if people look at Judge Barrett and determine their opinion based on her qualifications, I think people will be reassured that this is a high-quality person.
And if it costs you your seat, is that a worthy trade-off?
Huh?
I said, and if it costs you your seat,
I think that is not even a remote consideration for me.
Well,
Trust me, I know South Carolina. Amy Barrett fits South Carolina pretty good.
What I was going to ask was, what do you and other embattled Republicans in battleground states need to do to salvage their races and preserve the
I will just say this.
key states?
I've been following my race pretty close, probably closer than most. I'm working hard, and I'm being challenged unlike any other time. I like where I'm at. I've always known where I'm at. I know that in my state, conservative judges are preferred over liberal judges. In terms of how this affects the election, time will tell. In terms of her qualifications to be on the Supreme Court, I think it's beyond questioning that she's qualified. Sotomayor and Kagan, to me, were extremely well qualified. They had different political views and different judicial philosophies, but it never crossed my mind that they were not qualified. And if you apply that standard to Judge Barrett, I think we're in good shape. Thank you.
Are you campaigning this weekend?
I think so. I gotta check. What's the day?
Tuesday.
And if he thinks he's going to airdrop in one or two items and call it a day, he's overlooking the obvious. We have millions of Americans who are unemployed, who are not going to be receiving the weekly checks they need to survive. We have businesses that need help across the board, state and local governments. help when it comes to more screening. I mean, the list is comprehensive, and he knows it. Somehow he is arguing for small ball while the president's saying, let's have a big idea. Wouldn't it be a breakthrough if the president and Senator McConnell actually got together and put together something as a Republican proposal so we can get this done? I think the people across this country are fed up and frustrated by the fact that we're sitting in this room contemplating a new Supreme Court justice at a time when they're contemplating where their next meal's coming from. I mean, to me, this Senate Republican majority is out of touch with reality in this world. Maybe this is what Senator McConnell's hearing in Kentucky, but I doubt it.
I'll tell you what it is. It's very simply a fig leaf. He is feeling the heat, which we're raising in this room, that Republicans are rushing and jamming through a nominee who will take away health care in the midst of a health care crisis. And so he feels shame and embarrassment, as he should. And he's trying to provide that fig leaf for himself.
Senator Durbin, you have previously said that you're going to be talking to Senator Schumer.
Haven't done it yet. Good question, but there isn't no conversation tonight.
Okay, what about via committee vote? Will the two Democrats be boycotting that?
I don't believe any decision's been made. We have to talk that over.
So then both the committee vote and the floor vote, as far as strategy is concerned, that's going to be discussed between you and Leader Schumer?
Well, we'll talk about the next step. As I mentioned to you earlier, Chairman Graham has decided to accelerate one of the stages of the hearing, and I don't think we've had a conversation yet among us ourselves as to how to react to it. They are just hell-bent on getting this done as fast as possible. And it's because at least 4 of them are in death-defying re-election campaigns. They want to get out of town as fast as they can once they get this job done.
And they're, as you can see in the committee room, they are running away from the issues as fast as they can. They don't want to talk about health care and what she may do to it. They don't want to talk about any of the issues where the American people are against them. The sooner they can get the escape hatch, the better.
One question more if you have any.
Oftentimes a vote on a nominee in this committee gets held over for a week. Do you have confirmation from the chairman that it won't be held over and the vote will actually occur this week?
Holding it over a week is a tradition in the committee under the rules, and we hope that Chairman Graham will abide by it. But what it's held over from is the question now. Is it going to be from Thursday or sometime next week? We just don't know the answer to that. Okay? Thanks, everybody.
Thanks, everyone.
Hey, Senator Blumenthal, can I grab you a second? Hey, that's John Burton. Just trying to do a call for you. This is very important.
If you missed any of today's Supreme Court confirmation hearing for Judge Amy Coney Barrett, head to our website to watch the hearing in its entirety or search for portions of interest. That's online at cspan.org. Also, on tomorrow's Washington Journal, we'll get your reaction to the confirmation process by taking your phone calls and text messages. Washington Journal is live every morning.